When that sponsorship email hits the creator's inbox, creators generally focus on one thing. How much are they going to pay me? How much are they going to pay me? But a lot of companies focus on something completely different. They want to know how many rights they can quietly take from you that you won't notice. So you need to be paying attention when you're reading a sponsorship contract. That's what this video is about. Well, most companies consider both parties, meaning themselves and you, to be sophisticated, and that you're dealing at an arm's length, which basically means that neither side is vulnerable, neither side needs to be protected. You're both big boys in this whole game. And most importantly, that both sides have had an opportunity to get independent legal counsel to look at this contract, which they're not incorrect about that. Creators, meanwhile, are just hoping they don't get screwed by this deal. You know, years ago, I did a lot of volunteer work for the Philadelphia Volunteer Lawyers for the Arts. And that was a nonprofit that helped creatives, musicians, artists, writers, that had legal questions. And the thing that I did was that I would review contracts that people had gotten, mainly writers. That was my hobby on the side. You know, at night I wrote a lot of fiction. And so this is like back, I'd say about 2015-ish. And PVLA would reach out to me, ask me if I wanted to handle this particular case. This woman's gotten a book deal for her, kids' book that she wrote, and she wants somebody to review the contract with her. So if I said yes, they would fax me over the contract. Yes, I said fax. They would fax me over the contract, and with her contact information, I'd give her a call, set up an appointment for the two of us to discuss this. I did this with many, many people. It only took me about 3 or 4 times to realize the people were not reading the contract. I'd start the phone call with, "What can I do to help you?" And they'd say, "Well, I need you to explain this contract to me. I don't understand it." And having already reviewed the contract, I know it's not written in legalese, it's written in regular English. So I would say, "Well, what is it in particular that you're having a problem with? What don't you understand?" And almost invariably, they'd say, "I don't understand any of it. I don't understand any of it." So we'd have to go through it from the very beginning, from the very first line, and just do it step by step by step to make sure that they understood everything that was in this contract. That's why I know that a lot of people who are getting their first sponsorship contract, they're not reading it. They're scanning it. That's another thing. Most people don't read anymore. It's like it gives them a headache or something. They just scan stuff, and they're looking for the important stuff. But you don't know what the important stuff is, because as we all know, the devil is in the details. You got to read that fine print. You have to read all of these clauses. And that's what this video is going to be about. Let's go through some of these very serious clauses that are in most contracts, but particularly sponsorship contracts. So in this video, we're going to be covering indemnity clauses, morality clauses, perpetual licensing, exclusivity traps, payment language, AI usage rights, and termination provisions. So if you're a YouTuber, an influencer, an Instagram person, a TikTok creator, whoever, most of these videos are meant for YouTube creators, but it applies to everybody in social media. This video could save you from signing one of the worst contracts of your career. These contracts are created by lawyers. And the lawyer's job is to protect the brand. And by the brand, I mean the company, not you. They're not trying to be fair to you. They're trying to be fair to the person who's writing their paycheck, which is the brand. So you have to be very, very careful. Most of these contracts, it's just like if you get a lease from somebody for an apartment, and the landlord is the one who creates the lease. Guess what? that lease is written in such a way to highly benefit the landlord, not the renter. Same thing here. So you need to pay attention. One thing to keep in mind, which this comes under, I'm going to do the 3 big mistakes that creators do when they get the sponsorship contract, and then I'm going to do, the 7 types of clauses that people have problems with. The second mistake is that they don't negotiate. But I'm going to get to that in 2 seconds. Why are sponsorship contracts considered dangerous? I don't know if dangerous is the right word, but they are fraught with peril if you're not being careful and if you're not protecting yourself. I think most creators think that these sponsorship contracts, they're just standard. They're just boilerplate. They're all the same, basically. They're all basically the same. And, the brands love that when the creators think that, because you know what standard means? Standard means written by lawyers to protect the company. And as I mentioned, these contracts are usually drafted by marketing agencies, corporate legal departments, advertising lawyers, sometimes talent management firms. Like maybe they want you to do a video about their football player that they represent or their musician that they represent. Their job is to minimize risk for the brand. Your job, on the other hand, is to identify what risk is being shifted onto you. Because believe me, there is a fair amount of risk being shifted onto you. Creators generally make 3 big mistakes. The first one I already mentioned. They don't read the contract. I don't know if it's because they're intimidated. I don't know what gives. I don't know, but or because people don't read stuff anymore. I mean, I read everything. I drive everybody crazy. Even when I go to the doctor or something, they say, "Here, sign this." I sit there and read it, and the nurses are like, "Oh my God, are you kidding me?" Looking at their watches. Oh, come on. And I just say, "Hey, I'm a lawyer. I don't sign anything without reading it. You shouldn't either. You might not be a lawyer, but don't sign anything without reading it and without understanding what it says." Just saying. Normally, creators, they look at the payment amount, they look at the deliverables, what's expected of them, and they look at the deadline. And if it looks okay to them, they just sign off on it, because what can you do? Well, actually, there's a lot you can do. Which leads to the second mistake that most people make, and that's that creators don't negotiate. They think that, well, this is just the way it is, and I guess this is, it's my first contract, and I guess I just have to accept it. They don't realize that everything in a contract is negotiable. Everything. There might be some things that are absolute no-goes for you, and there might be some things that are absolute no-goes for the other side, for the company. But you can always talk about it. You can always try to mitigate some of these problems. And so when I'm talking about these clauses, I'm also going to give you some of the things you can do to minimize the risks that are connected to one particular clause or the other. Even small creators can negotiate about, okay? One, you could talk about liability caps, because if not, they're going to hold you liable for everything. So have some liability caps put in there. You can have licensing duration. They want to have a license in perpetuity. You say, no, this license is going to be good for 1 year or 2 years, and open to negotiation after that. You can negotiate exclusivity periods, and we're going to talk about what exclusivity is in a couple of minutes. The payment timing, sometimes they don't want to pay you for 6 months. They're going to give you half up front and then half 6 months after you deliver the YouTube video or whatever it is that you're doing. You can negotiate that. You can change that. There's also approval rights. They're going to say something like the company has the right to approve this, and payment won't be made until approval is done. But they can keep insisting on revision after revision after revision after revision. Something that you thought was going to take maybe 3 days to get done can take 30 days to get done, because they don't like this and they don't like that. You can negotiate all that, but you have to do it before you sign the contract, not later. And of course, termination language. That can also be negotiated. So let's talk about the big one. This is the big one, the indemnity clauses. Another mistake that people make is that they think that this contract is just a small contract. They assume that small deals don't really matter. It's only a $1,500 sponsorship. But you have to think twice. The legal liability is not capped by the sponsorship value. So you can sign a small deal, but it can have massive exposure for you. The indemnity clause is one of the most dangerous clauses in any sponsorship agreement, and a lot of creators don't have any idea what it means. An indemnity clause basically means that if the company gets sued for something connected to you, you pay the losses. That can include legal fees, settlements that the company agrees to, attorney costs, damages, if the company has to do investigations, and any kind of penalties like regulatory penalties. You could be on the hook for all of it. Here's some dangerous language. The creator shall indemnify, defend, and hold harmless the company, blah, 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 blah. And sometimes they add in perpetuity. We're going to talk about that clause a little bit later. Those words are very powerful. Indemnify, defend, and hold harmless. I think you understand hold harmless. That's plain English. Indemnify, we've just explained. What's defend mean? Defend means that you pay the legal fees, and you pay them immediately. Not later, you pay them as soon as possible. So let's give an example. Say you're promoting a supplement, right? Maybe you're a health channel. And then somebody claims that that product harmed them, and they sue the company. The company then says, you made statements in your video beyond what we agreed to. That's them trying to push liability onto you. Say you accidentally use some copyrighted music in a sponsorship content in a video that you made. The brand then gets a copyright complaint. They're going to try and make you pay for it. A lot of contracts place unlimited liability on the creator. You're capable of negotiating some of these issues. You can negotiate liability caps. For instance, you could say that the creator liability shall not exceed the total compensation paid under this agreement. Which means even if they can make it stick that you're going to have to pay for their attorney's fees or whatever, you don't have to pay any more than what you received for this agreement. That shouldn't be a difficult thing for a company to accept. That seems fair. You also have to watch out for one-sided indemnity. Some contracts protect only the company. In fact, if I were you, I would assume that the contract that the company sends to you is mainly protecting itself. But what happens if it's the company that violated intellectual property laws? You shouldn't be able to be held liable for that, right? What if they give you false advertising information, advertising claims, let's say? What if their product creates some regulatory problems? You could certainly negotiate mutual indemnification. Even though it's not added to the contract that you get at first blush, you know, the first draft of the contract, it doesn't say that you're mutually indemnified. You can negotiate that and you can say, we want mutual indemnification in case you give us bad information, we rely on that, and now you have a problem or I have a problem. The second clause that's important, and is becoming more and more important as time goes on, These are called the morality clauses. And they are exactly what you think they are. A morality clause allows the company to terminate the relationship if the creator engages in some kind of behavior that harms the brand's reputation. Which, that seems reasonable, right? But it gets worse. It gets worse. The wording can be very vague and very subjective. Any conduct that may subject the brand to public ridicule, controversy, or reputational harm. Well, what does that even mean? Any conduct that may subject the brand to public ridicule, controversy, or reputational harm. First of all, who decides that it has caused this kind of reputational harm? Who decides that? Well, guess what? The company does. That's the problem, and that's why it's so dangerous. And, nowadays, the internet and social media, it just creates these cycles of outrage constantly, right? Creators can become controversial overnight or for something that happened 15 years ago. For instance, the company might think that you're controversial because things come to light. Tweets from years ago, when they used to be called tweets. Are they still called tweets? I don't know. I'm not on X. Political opinions, jokes, old videos, some kind of public dispute that you're in. You went to your local town hall meeting and there's something that you feel very strongly about, and you made a big fuss about this. You also made a video about it because, that's what you do. And now this is all very controversial. The company does not want to be involved in this kind of political talk and rhetoric. You could also have a problem if you're in association with other creators and the other creators are having problems. So you see how this can become a problem? You don't want a vague morality clause. It gives brands way too much discretion. Think about the financial risk. Some morality clauses allow companies to terminate payment, demand refunds. Generally they give you half up front and half when you deliver. They can remove campaigns altogether. They can cancel future installments. Imagine that you've completed the filming, you've done all the editing, you've even posted it, and then the company decides that you have done something that makes you too controversial and they want to back out of the deal. Can they do it? Here's some better language you can use if you're going to negotiate. First of all, you should push for objective standards, not subjective. It harmed us. Well, we want to know some objective standards. What do you mean by that? Define the misconduct. What are the things that, as the creator, you're not allowed to do? Make it as specific as possible. Another thing, you can look at criminal conviction standards, right? That is normally beyond a reasonable doubt. So you can add that kind of language that the creator caused reputational harm to the brand beyond a reasonable doubt. You can also add a line that the evidence that the company presents to prove that it suffered some kind of harm because of you, that the evidence that they used was credible and it was reliable and it was sufficient to be able to prove this charge. They should also allow you some time to cure whatever the problem is, all right? For instance, what I had said about maybe you accidentally used some music that was copyrighted. They should give you a certain period of time, 30 days or something, to cure whatever the problem is. Believe me, most of the time, they're not going to give it to you unless you ask for it. You should also just avoid broad language. I think I already touched on this for a hot second, but avoid broad language like embarrassing, or offensive behavior or created negative publicity. I think it was P.T. Barnum that said there's no such thing as negative publicity. I think he said something like, I don't care what they write about me in the papers as long as they spell my name right. You know, is there such a thing as negative publicity? Look, this is exactly what Trump does all the time. It's how he got so much publicity that first term, remember? You know, oh my God. I mean, every time he turned on the TV, CNN, Fox, MSNBC, they were all talking about Trump, 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 because he would just create this whole big brouhaha. And Ann Coulter, I don't know if you know who she is. Ann Coulter is a conservative commentator. She used to be on Bill Maher a fair amount. And I noticed that about her too. That first of all, I only saw her when she had a book coming out. And she would open up her mouth and say some of the most outrageous stuff. And it was just to get people talking about her. So another thing you want to consider is that there should be some kind of damages. You know, is there, what was the reputational harm? Obviously, like, you're going to need some objective standards for that. But what were the damages to the brand? That's something that happens in lawsuits all the time. I used to have people come into the office and I want to sue so and so for defamation, blah blah blah. Oh, that's actually another thing in here, defamation. And I said, well, what harm was done? How did you suffer? Did you lose your job over this? No, but she embarrassed me. So what? There's no actual harm done to you. So that's the morality clause. Now let's look at one that is probably the most abused clause in creator contracts. And I think it's one that creators, generally speaking, undervalue it. This is the perpetual licensing clause. What is a licensing clause? When you create sponsored content, the copyright generally belongs to you, unless it's been transferred. That's for a different video. So the brands need permission to use your content, and that permission is called a license. Watch out for this phrase: perpetual, irrevocable, worldwide license. Perpetual, of course, means forever, and forever means forever. The company can continue using your face, your likeness, your voice, and think about AI, right? Your content, your testimonials, and your clips. Years after the sponsorship ended. And it's even after you no longer support the company. Let's just give one quick example. You promote a startup app in 2026, but in 2029, the company gets sold. But in 2029, the company gets sold. They change ownership. And then what happens? Maybe the quality of the product begins to decrease. Maybe there's some kind of controversy with the new owner, or there's any host of things that could happen when new owners come in, right? They will still have the right to run ads with your images forever. That can damage your personal brand. Another issue is the whole AI stuff. Some of the more recent agreements are adding language allowing AI modeling, synthetic voice usage, digital replicas, machine learning training, or derivative content creation. So you absolutely have to watch out for this kind of language. So what can you do? Negotiate. Like I keep saying, you can try limiting the duration. For example, it's not in perpetuity. It's for the next 3 months, or for the next 6 months, or for 1 year, right? You can limit the geographic scope. You say just within the United States, or just within the Western Hemisphere. You can also add what you want to add. There's to be no TV usage of my images. There's to be no AI training. Maybe you're going to decide to limit the platforms that it's allowed to be on. This is for TikTok only, or this is for Instagram only, or YouTube only, or YouTube Shorts only. Shh. My cat's crying because he's hungry, as usual. So these distinctions matter. And listen, I'm going to say it again. Don't be afraid to, especially if this is like your first sponsorship, don't be afraid to say, look, I have some concerns about this contract. I want to talk to you a little bit about these clauses. And then have your list already prepared that you want this instead of that, you want that instead of this, okay? Because it's going to make a huge difference. The next concern you need to have is for exclusivity traps. Exclusivity means that you cannot work with competing brands for a certain period of time. So, I mean, this is typical. I mean, salesmen do it all the time. Years ago, I worked way in the beginning when I was like in my mid-20s. I worked at After Six, which was a tuxedo manufacturer, and there were, I don't know, 12, 15 salesmen throughout the country that were selling these tuxedos to retailers. And I'm sure that in their employment contracts, they had an exclusivity clause that said, if you leave the employ of After Six, you're not allowed to work for another tuxedo manufacturer. And there's good reason for that. They have inside knowledge, right? You have inside knowledge of, in this case, the salesman would know a lot about After Six. So if they then go and work for another tuxedo manufacturer, they could give that information to them, and that could hurt After Six because you're giving information to their competitor. Let's look at an example that maybe a YouTube channel might have. Let's say you have a healthy living channel and you get a sponsorship deal to promote some new energy drink. And then you discover, as you're reading the contract, because at this point you're going to be reading the contract, not just scanning it, correct? You read the contract and you discover that the contract bans partnerships, your partnerships, with any other beverage company or supplements or fitness products or wellness brands or nutrition companies. They have a whole list of stuff. And the kicker, and similar categories. Okay? That could wipe out half of your sponsorship market. Probably the biggest problem is that a lot of these contracts never actually define who the competitor is that you're not allowed to work with. That gives the company broad interpretation power down the road. Another trap, time length. We mentioned it a little while ago. Watch for excessive exclusivity periods, like 12 months, 24 months, 3 years, or worse, indefinite periods. That's dangerous, unless the compensation justifies it. You know, that's another thing you can negotiate. If they say, no, this is a deal breaker for us, you cannot work with any other company except ours You can't promote any other product on your channel for the next 24 months. Well, then guess what? You want a whole lot more than $1,500. Right? They're going to have to pay extra for that. You know what? And some agreements prohibit mentioning competitors anywhere. Let's say your sponsorship is for YouTube videos, but you also have Instagram and TikTok, X and newsletters and emails, and the agreement says you're not allowed to mention other products anywhere. That's something that maybe you can strike, and by that I mean have them take that out of the contract, because why should you, if this is only for YouTube videos, why should your Instagram account have this problem? That doesn't make any sense. It doesn't seem fair. It makes sense, but it doesn't seem fair. So here's a better negotiation strategy. When you're looking at this particular clause or these clauses, right, limit the duration of time that it's good for, and the platforms, your specific competitors, have them say, I don't want you talking about X brand because that's our direct competitor. Have them put it in the contract that these are the 5 competitors you're not allowed to deal with. That might be enough for you to be, okay, that's fine. I won't talk about those 5 because you have another 6 or 7 over here that you've been thinking about. The narrower the exclusivity, the better for you. Now, let's talk money. Okay? These are the payment clauses. These are some clauses that can hurt creators. So when we talk about this, we're talking about when are you going to get paid? A lot of brands pay creditors absurdly late. 120 days or 6 months later. But usually it's going to be like net 60. Net 90? It's getting a little iffy. Net 120? Careful with that, because that means that they don't have to pay you for months after you've already delivered on what they requested. You've done your end of the deal, but they don't have to pay you for 3 months, 4 months, 6 months. Be careful, and that's something you can absolutely negotiate. Of course, they could always throw it back at you and say, nope, this is what we always do. This is our standard contract. You say, well, this doesn't work for me. This is why people get lawyers involved, because they don't, a lot of times people don't want to be nasty, but, lawyers, we don't mind being nasty. That's our job. That's our job, is to do the best we can to defend you. Okay, I was going to talk about termination clauses, but it's getting way too long. This video is getting way too long. So I'm just going to skip right down to how creators can protect themselves. Here are some practical steps that you can take. Number 1, never rush a sponsorship contract. If they send you the contract on Wednesday and then say, by the way, we're really under the gun here, we need you to have this back to us by Friday at 9 a.m. I would suggest walking away. You need time to be able to review this. They've had plenty of time to create the contract. You need time to review it. So don't rush it. Number 2, use only written communications. Okay? Everything should be done through email. I don't mean texts. I don't mean DMs. I mean email. Because you want to create a record. And keep in mind that if you have a written contract, you can't just change it verbally. They look at the 4 corners of that contract, and what it says is what it says. The time to make the changes is before you sign it. For instance, if you have 30 days to get this video to them for approval. If you call him up at day 20 and say, I'm going to need another 2 weeks for this, and he says, yeah, sure, that's fine. Don't be surprised if when it comes time to get paid, they're going to say you breached the contract because it had to be here within 30 days. Yeah, but you said. That doesn't matter. Everything should be in writing. And by that I mean email. Or real letters, but I don't think most people do real letters anymore. Create a contract review checklist. Okay? That means you should be reviewing indemnity, exclusivity, licensing, the payment timing, the termination, what kind of AI usage you have granted to them, owns the video after you've produced it for them. Do you own it or do they own it? Double check what the contract says about that. Another thing are the morality clauses too. Another thing that should be in the contract, which I didn't mention, is let's say you're going to have a dispute over this. Like I said earlier, it's supposed to be within so many days, but he gives you a verbal extension, so now you have a dispute. It should be in the contract who has jurisdiction over this particular matter. What state is it going to be? A lot of corporations are incorporated in Delaware. I think there's more corporations incorporated in Delaware than any other state because they're good with taxes, apparently, Delaware. So it might say it right there in the contract. It should say what state's laws are going to, especially, and this is especially true if you're in one state and they're in the other state, what state's laws are going to control, who has jurisdiction over this. Another thing that should be in the contract is that you should say whether or not, instead of filing a lawsuit, you first have to do mediation or arbitration. That should be in writing. And that's a way to avoid like lengthy, costly litigation, that you want to do mediation or arbitration. So that should also be on your checklist. I mean, the truth of the matter is, the wrong contract can cost you a whole lot more than the deal ever paid. And in this creator economy, your likeness, your content, your reputation, your intellectual property, they are the business. Protect them accordingly. If you found this helpful, please subscribe to CAP for more videos on creator legal protection, on creator asset protection, digital asset security, contracts, lawsuits, business structures, and protecting your online brand. And just so that we're clear, as a disclaimer, this is meant for informational purposes only. This entire video is just for informational purposes. I suggest that you talk to a lawyer for the specifics in your case because each case is going to be different. And there's been no attorney-client relationship developed here if you follow my advice on here. I can give you very sound advice, but the specifics of your case might be different. So go contact an attorney. And that's it. If you want to see more videos about this, this is what I do. It's the whole purpose of the channel. So hit subscribe, hit like. If there's somebody that you think might be interested in this, maybe you're in some kind of a group that might find this interesting, I would strongly suggest that you share it with them. And I will see you in the next video.